it's easy for you and us commenting to say Trump v. U.S. is not real law. But, the special counsel's office has to pretend as though it is.
Absolutely. Welcome to Law and Chaos, where Jack Smith is back, baby, and he's ready to call John Roberts' bluff. There's a superseding indictment in Trump's election interference case, and meanwhile, Republicans in Georgia are winding up to steal this election. Plus, for subscribers, remember the Hatch Act, and how does that impact the Trump cases? We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye. With me, as always, is Andrew Torres. Andrew, how are you?
I'm great, Liz. I am very, very excited to cover the stories we're taking a look at today. I know everybody wants to know what's going on with the superseding indictment, and I think you've got some other fun surprises planned for us.
Indeed. It's been a long week, so we're going to skip the news roundup today, and we'll just check in with our chief religion correspondent.
Oh, God, no.
I look at California. I gave a speech. I had a crowd so big. I said, "There's no way I could lose California," but automatically they mark it down if you're a Republican as a loss. That you lose by 5 million votes. I said, 5 million votes. I guarantee, if Jesus came down and was the vote counter, I would win California. Okay. In other words, if we had an honest vote counter, a really honest vote counter, I do great with the Hispanics. Great. I mean, at a level that no Republican's ever done. But if we had an honest vote counter, I would win California.
You think so?
Oh, I think so. I do. I see it.
That Jesus, he's crafty with the counting.
I just want to point out the former president of the United States does not understand denominators, right? Like, yes, there are more Trump voters in California than there are in any other state in the union. That's because there are more people in California than any other state in the union. I should not have to say this.
Yeah, even Dr. Phil was like, bro, I don't know, man.
I like how, as we record this, Kamala Harris is doing the interview with Dana Bash, which, Trump is bleeding about or whatever. But like, Trump managed to screw up an interview with Dr. Phil, and J.D. Vance managed to screw up buying donuts. So, glass houses, yeah. People. Okay. Our first story concerns the superseding indictment procured by special counsel Jack Smith in Trump's election interference case, pending before Judge Tanya Chutkan in the U.S. District Court for the District of Columbia. A superseding indictment is essentially an amended indictment, right? Because of the Fifth Amendment, right? Unlike a civil complaint where you can just file an amended complaint, in a criminal indictment, the government has to go impanel a new grand jury and get them to vote out a revised indictment, which the special counsel's office did. And by the way, the standard for any grand jury to issue an indictment, be it original or superseding, is probable cause, right? So this is now twice, or I guess 3 times if you count Florida, that Jack Smith has been able to go to 2 different groups of ordinary citizens and convince them that there are reasonable factual grounds to believe that Donald Trump committed crimes, which there are.
Yeah, I mean, 4, because there were 2. There was a superseding indictment in Florida, too. So we're talking about 4 grand juries.
A fair point.
Counterpoint, witch hunt. And I have it on good authority from the nation's finest legal mind that this is definitely proof of election interference. And it means the case has to be thrown out under the 60-day rule, which we're going to talk about. But first, let's talk about actual law. Remember, the D.C. election interference case was stayed while Trump appealed the denial of his presidential immunity claims all the way to the Supreme Court, where, on a 6-3 vote, the court helpfully invented, out of whole cloth, a brand new doctrine of criminal immunity for ex-presidents. So now the Supreme Court has remanded the case to the trial court to let Judge Chutkan try and figure out how to go forward in light of this, fakakta new rule they just made up. And the Supreme Court had one more bonus parting gift for Donald Trump in that it sat on the mandate for a full month before releasing it on August 1. That was so sweet of them.
Yeah, right.
So Judge Chutkan immediately got to work asking the parties to come together with a briefing schedule to try and hammer out, how they're going to proceed with this crazy ruling from the Supreme Court. And on August 8th, the special counsel requested an extension of time to figure out how to deal with this abominable ruling. And of course, Trump was like, hey, take all the time you need. No problem. So the joint status report, which was due a couple of weeks ago, is going to instead drop tomorrow, Friday, August 30th, as will this podcast.
Yeah, and let's get this out of the way. This trial is not happening before the November election. Sad to say that. And if Trump wins, it's not happening at all, right? Because he will fire Jack Smith on day one and order Attorney General, I don't know, Carrie Lake to drop the cases against him and indict
Jeff Clark.
Commander Biden for aggravated pooping on the White House lawn instead. I mean, that's if we're lucky, right? So look, this superseding indictment is about what happens if Kamala Harris wins. And as it turns out, Jack Smith was busy during that 3-week extension.
Yeah,
right?
he
was not
was.
just preparing a status report. He got another grand jury impaneled, right? Because the first one had been dissolved after they returned that first indictment. He asked for a superseding indictment against Trump that the special counsel's office crafted to survive the new rules invented by the Supreme Court.
Yeah, I am so curious to know if Trump knew this superseding indictment was coming,
I
or
think
if his
not.
lawyers knew. I mean, yes, he lost his shit on Truth Social, which suggests that he didn't, although he loses his shit on Truth Social every day of the week. Right.
Yeah,
anyway,
it's not a
it's not
barometer.
super important whether he knew. But let's talk about these new immunity rules, because they really were designed to blow up this case in particular. Andrew, you and I went on record saying we didn't see how this case would survive in light of the court's decision, and it may not, but it seems like Jack Smith wasn't quite ready to throw in the towel. So the Supreme Court's immunity ruling went beyond saying that presidents are immune for acts taken in connection with their official duties. That's bad enough. But the court also said that if the government tries to prosecute an ex-president for non-official acts, prosecutors can't even introduce evidence of official acts to prove culpability, even though that makes no sense and would make it impossible to prosecute crimes like bribery. So here's some language from the opinion. In dividing official from unofficial conduct, courts may not inquire into the president's motives. Such an inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose, thereby intruding into the Article 2 interests that immunity seeks to protect.
Yeah, and that is so crazy that Justice Amy Coney Barrett dissented from that part of the opinion. I mean, it still got 5 votes because our Supreme Court is irretrievably broken, but Justice Barrett noted correctly that prosecutors couldn't possibly convict a president for bribery under this rule, that you can't introduce evidence that would allow a jury to inquire as to why the president does anything in connection with his job.
Right. So, for example, if I pay Donald Trump $1 million to be named ambassador to Corfu, if there isn't an ambassador to Corfu, there bloody well should be. And if I pay him the money and he names me as ambassador, the Roberts Court seems to suggest that a prosecutor can't ask a jury to evaluate why Trump named me as ambassador. And that can't be right. That means you could never convict a president of bribery. Or as Justice Barrett put it in her concurrence, to make sense of charges alleging a quid pro quo, the jury must be allowed to hear about both the quid and the quo, even if the quo, standing alone, could not be a basis for the president's criminal liability.
Yeah, and that put Chief Justice Roberts on, I guess, what counts for the defensive for him, right? So he responded to that criticism in footnote 3 of the majority opinion, which says, but of course the prosecutor may point to the public record to show that the fact that the president performed the official act, and the prosecutor may admit evidence of what the president allegedly demanded, received, accepted, or agreed to receive or accept in return for being influenced in the performance of the act, right? But what the prosecutor may not do, however, is admit testimony or private records of the president or his advisors probing the official act itself. Allowing that sort of evidence would invite the jury to inspect the president's motivations for his official actions and to second-guess their propriety. And look, I think that footnote is going to form the linchpin of how Jack Smith is going to argue that he can proceed with this case under the superseding indictment. He's going to say, look, I've stripped out everything charging Donald Trump with crimes relating to things that he did as an official act as president, and nothing in the indictment rests on either testimony or records from Trump or his cronies, and then he's going to use that language, probing the official act itself.
Yeah, we talked about this in the newsletter yesterday. We described it as Jack Smith calling the Chief Justice's bluff, because this case is definitely going to wind up back at the Supreme Court. This is, Judge Chutkan is not the final stop here. And the question is going to be whether Chief Justice Roberts really meant those words or not, whether he really meant, no, you can't prosecute Trump for everything, or like, go ahead and make your case.
Yeah, and look, a lot can happen over the next year or so, right? Trump could lose the election. John Roberts could develop a sense of shame. The composition of the Supreme Court could change, right? Perhaps the horse will sing, right? But whatever happens, this superseding indictment is the path forward.
All right. We will be back after this brief ad break, unless you are a subscriber at lawandchaospod.com or on patreon.com/lawandchaospod, in which case no commercials for you ever. Otherwise, see you in a sec. And we're back. So the new indictment largely tracks the original one with several important differences. The 4 counts are the same. That's conspiracy to defraud the United States under 18 U.S.C. Section 371, conspiracy against the right to vote and to have one's vote counted under 18 U.S.C. Section 241, obstruction of an official proceeding under 18 U.S.C. 1512c2, and conspiracy to obstruct an official proceeding under 18 U.S.C. 1512k.
Yeah, and put a pin in those last two, the 1512 charges.
So the question is, how did Jack Smith edit the complaint to comply with the immunity ruling? And the most obvious change is that he ditched unindicted co-conspirator number 4, Jeff, we'll call you if there's an oil spill, Clark.
Well, unindicted federally, right? Jeff Clark is definitely indicted in Georgia. I mean, at least for now.
Yeah, and he's facing a bar complaint in D.C., which he now says has to be dismissed because of the immunity ruling. He's a creative thinker.
Or removed to federal court, or, right, yeah.
Yeah, well, he's definitely trying to still remove it to federal court, and he actually pointed to the immunity ruling for reasons I could not fathom as reasons that his bar complaint had to be removed to federal court. But okay, to recap the Clark allegations in the Trump indictment. In the aftermath of the election, Trump pressured the Justice Department to announce sham investigations into non-existent voter fraud as a pretext for the swing state legislatures to steal the electoral votes in those states for him. Attorney General Bill Barr called this horseshit and refused to do it, though.
Yes, but, before we start thinking Bill Barr isn't one of history's greatest monsters, I think it's pretty clear from his January 6th testimony that his reasons for not doing so were largely pragmatic, right? Trump needed to steal 6 states to overturn the election, and if it had been just one, I'm not super confident that Bill Barr's ethics would have kept the Republic together. That may just be
it's interesting. It's an interesting counterfactual, right? He did, to be fair, we're going to talk about Georgia in the second half of the show. He forced out B.J. Pack, the U.S. attorney who was presiding over, the Atlanta division. I'm not sure which the divisions are in Georgia, and put in another district attorney whose name is, I think, Bobby Christina. And that guy couldn't find it either. I mean, he tried. Barr did try to find the fraud. He just couldn't find it. Anyway, he actually resigned on December 15th rather than tough it out another day under Trump. He did not want to get fired by a tweet, so he was trying to get out of there without, with his dignity intact or whatever. I don't see how he's got any dignity left, but that's not the point. So after Barr was gone, Trump was turning to more compliant sources who were, willing to say whatever he wanted and do whatever crazy shit he asked him to do. And if we wind up in a second Trump administration, that's all it's going to be.
Yeah, we'll start there. That's right.
Exactly. So there was a 6-hour period that was on December 18th when Sidney Powell got herself into the Oval Office with Mike Flynn and the overstock weirdo Patrick Byrne, and sort of temporarily persuaded Trump that she was going to be the election czar and declare martial law and seize all the voting machines. But nobody in the administration would do it, and that kind of fizzled. After which, Trump decided he would make Jeff Clark, who was then, he had been head of the environmental division, but so many people were gone that I think he was head of the civil division at that point. But Trump had this plan to make Clark acting attorney general and fire Jeffrey Rosen, who was the actual attorney general, because Clark was wanted to send out this letter to Georgia and then all of the swing states saying, we found outcome determinative electoral fraud in your state. So you, the legislature, should steal the electoral votes and give them to Trump.
Yeah. Of all the many things I appreciate about you, Liz, perhaps none tops you teeing me up to talk about my favorite Republican, Assistant Acting Attorney General Rich Donahue. You've already hinted at his most famous line. He was the one who told Jeff Clark to his face, "You're an environmental lawyer. How about you go back to your office and we'll call you when there's an oil spill?"
It worked.
Right, but look, Donahue was not just cracking Schwarzenegger-esque one-liners, right? Like, he was also behind the scenes calling everybody he knew at the DOJ, and that was pretty much everybody, and getting their promises that if Trump actually named Jeff Clark acting attorney general, they would all resign en masse, right? So here,
and the White House counsel's office.
Yeah. And so I'm going to quote from his January 6th testimony, because unless the Supreme Court overturns the Trump v. U.S. immunity decision, Donahue will never be able to testify to the jury, and that's a shame. So set the stage. Donahue is testifying that Trump asked him, hey, well, what would you do if I named Jeff Clark acting attorney general? And here's how he responded. Sir, I would resign immediately. There's no way I'm serving 1 minute under this guy. And we're not the only ones. You should understand that your entire department leadership will resign. Every assistant attorney general will resign. Mr. President, these are not bureaucratic leftovers from another administration. You picked them. This is your leadership team. You sent every one of them to the Senate. You got them confirmed. What's that going to say about you when we all walk out at the same time? And I don't even know what that's going to do to the U.S. attorney community. You could have mass resignations among your U.S. attorneys, and then it will trickle down from there. You could have resignations across the department. And what happens if, within 48 hours, we have hundreds of resignations from your Justice Department because of your actions? What does that say about your leadership? If anything is ever called for with wit like that, I could be an action hero, right? Like it's that testimony. And it worked. Trump backed down.
Yeah, I'm glad you enjoyed talking about it on our air, because it's not going to happen in this case. Although, interestingly, I was listening to the Lawfare podcast, and they said, well, maybe the January 6th report is a public record now, and it's going to come in because on the public. I think that is
not for the truth of the matter, but it's an interesting.
Yeah, I mean, I think this is one of those kind of interesting law questions. I think the reality is that the Supreme Court would never, not ever, let it come in.
Yeah, this Supreme Court, which is a good reason to have a new one. So
yeah, for sure. Okay, so Chief Justice Roberts said, this is what he said about the Clark scheme. He said, Trump's threatened removal of the acting attorney general implicates conclusive and preclusive presidential authority. The president's power to remove executive officers of the United States whom he has appointed may not be reviewed by the courts. The president's management of the executive branch requires him to have unrestricted power to remove the most important of his subordinates, such as the attorney general, in their most important duties. So that's the end of that. Clark, by the way, has pinned a tweet saying that Jack Smith, whom he compares to Stalin's secret police chief Lavrenti Beria, should have just dismissed all charges against Trump after the assassination attempt in Pennsylvania, for the good of the country, because he's a piece of shit. But whatever, that's a piece of shit who is no longer in this case.
Yeah, okay, but that's pretty much it for paring down the substantive allegations in the superseding indictment, right? All of Trump's other co-conspirators remain in the superseding indictment with new allegations that none of them, quote, were government officials during the conspiracies, and all of whom were acting in a private capacity, end of quote. So that is our greatest hits list: Rudy Giuliani, Sidney Powell, John Eastman, and co-conspirator 6, whom we believe to be campaign consultant Mike Roman, and, the guy who really coordinated the fake electors scheme on the ground.
Right. So the fake elector stuff stays in. That was characterized as a fraud perpetrated by candidate Trump rather than President Trump. Similarly, the call to Georgia Secretary of State Brad Raffensperger, in which Trump and his chief of staff Mark Meadows urged Raffensperger to find 11,780 votes, which is one more than we have because we won the state, which they did not. So that call stays in because monitoring state elections is not part of the president's job, although his lawyers have argued before and definitely will again that it is. They've said, well, he has a general constitutional duty to take care that the laws of the nation be faithfully executed, and that's what he was doing.
Yeah, funny how they can find all these unenumerated rights and powers when we're talking about Trump. But, if it doesn't say women have a right to abortion in, Amendment 7, then it doesn't exist. Okay, I'm sorry. I'll get off the soapbox.
Okay. I think the most surprising thing for the both of us is that the superseding indictment left in Trump's efforts to pressure Mike Pence to break the law, to overturn the election, particularly because there was some extremely skeptical language in the immunity ruling itself. The Chief Justice conceded that when Pence presided over the Electoral Count certification on January 6th, he was acting in his capacity as president of the Senate and therefore as a member of Congress and not as a member of the executive branch. But Roberts added that, quote, the president may frequently rely on the vice president in his capacity as president of the Senate to advance the president's agenda in Congress, which, that is true, right? Kamala Harris has broken many a tie. But that's not what we're talking about on January 6th. Right. Pence wasn't there to log roll some Republicans about a border wall or whatever. He was at a constitutionally mandated special joint session of Congress convened solely to count the electoral votes. And his duties were actually prescribed in the Constitution. So he was definitely not doing president stuff.
Right. Yeah. The furthest that Chief Justice Roberts could go was to say that if Jack Smith wants to introduce evidence related to Vice President Pence, it is, quote, ultimately the government's burden to rebut the presumption of immunity, to which the special counsel's office was like, challenge accepted. And they returned a superseding indictment that characterizes Trump's conversations with Pence, and in particular, those where Trump had John Eastman try to convince Pence's office, his staffers, that, certifying the election was discretionary. He could choose to do it or not to, and not ministerial.
Yeah, put a pin in that one.
Yeah. And urging Pence, to just not certify swing state votes or, at minimum, throw in some delay, send it back, throw a monkey wrench into the process. And at that, all of that had absolutely nothing to do with either Trump or Pence's jobs in the executive branch, the only thing to which they could be entitled to immunity under Trump v. U.S. So here's what the superseding indictment says. It says, Trump had no official responsibilities related to the certification proceeding, but he did have a personal interest as a candidate in being named the winner of the election. All of the conversations between the defendant, that's Trump, and the vice president described below focused on the defendant maintaining power.
Yeah, I am quite sure that is going to be the locus of most of the argument about this case, that the Trump's lawyers are going to come out and say, no, all of this was official and all of it has to go out, right? And that they'll take this one all the way up to the Supreme Court. So that's going to be the call of the 6 conservatives on the Supreme Court. And look, this is what I'm saying. It's a bluff, right? He's saying, how much of your legitimacy do you want to squander on this thing? Because if it comes back, it'll mean that Trump lost and, he'll be a loser.
Yeah, I'm curious your thoughts on this, because in my view, you could go forward with this case under the superseding indictment and lose the Pence stuff, right? As long as you still have the fake elector scheme in place, I think that's kind of the thread that holds the story together. So maybe Jack Smith is prepared to give a little bit on this. I don't know. What are your thoughts, Liz?
I don't know. I mean, a man's reach should always exceed his grasp. So I understand what you're saying. Maybe he's asking for things that he knows he's not going to wind up getting. I think it's so up in the air, right? Because we don't know what's going to happen in November, right? If Trump tries to do this shit again, what are they going to do? Trump is such a crazy character that I think treating it as if it's a real legal ruling, nobody can treat it as if it's a real legal ruling. And in some sense, it's a political statement by the court's conservatives. And as you said, that it's going to be different. And as you said, a lot can change. And also, as we said, the only way this comes back if Trump is a loser and reappears in his loser pants.
Yeah. And look, that's a challenge. It's easy for you and us commenting to say Trump v. U.S. is not real law, but the special counsel's office has to pretend as though it is.
Absolutely.
Okay. And so before we turn to the question raised by Donald Trump as to whether the superseding indictment violates the 60-day rule, spoiler alert, it does not. I also want to point out that Jack Smith updated the 2 obstruction charges against Trump. That's the 1512 charges I told you to put a pin in, to comply with yet another case handed down by the Roberts Court at roughly the same time as the immunity decision. This was one called Fischer v. U.S. And that case was brought by a January 6th rioter, a guy named Joseph Fischer, who argued that his 1512 conviction for having obstructed an official proceeding was invalid, even though he definitely obstructed an official proceeding, right? Like the joint session of Congress convened to count the electoral votes that was definitely obstructed when an angry armed mob broke down the barriers, walls, and windows and drove said members of Congress into safe houses, right? But Fischer argued that 18 U.S.C. 1512, the obstruction statute, required the government to prove that he also destroyed documents while making members of Congress run in terror, even though the statute absolutely positively does not say that, and it makes no sense. And virtually every judge to ever consider what 1512 meant for decades has rejected that argument. I mean, we covered this in more depth in episode 43.
Right. But the bottom line is that despite all that, the Roberts Court agreed with Fischer's arguments and threw out his conviction, or at least on that charge, essentially ruling that you can do a coup as long as you don't step on a piece of paper while you're doing it. And because 2 of the 4 counts in the original Trump indictment were 18 U.S.C. 1512 obstruction charges, the superseding indictment adds a few lines to bring those 1512 allegations in line with the Supreme Court's demands in Fischer. So, for example, paragraph 93 now reads that after Trump whipped up a mob and pointed them at the Capitol as members of Congress were literally fleeing for their lives, quote, staffers evacuating from the Senate carried with them the legitimate electors' certificates of vote and their governor's certificates of ascertainment. So that's designed to meet Fischer's requirement that the government prove the defendant impaired the ability or integrity of records, documents, objects, or other things used in the proceeding.
Yeah, thank God they've now alleged that, paper got hurt too. So, okay. All right. With that in mind, those are the changes in the superseding indictment. Now let's tackle Trump's argument about the 60-day rule. Oh, Liz.
All right, here you go, guys. It is DOJ policy that the Department of Justice should not take any action that will influence an election within 60 days of that election, but they just have taken such action. Voting starts on September 6th. Therefore, the DOJ has violated its own policy. Election interference. All of these Comrade Kamala Biden hoaxes should be immediately dismissed.
I love how your Trump sounds nothing like Trump, but is so evocative of him. Anyway, so
thanks.
That is 100% not true, and we're going to unpack why. But first, let's start out with what is the 60-day rule. And Liz, I know you're going to be shocked, but turns out it's not the stuff Trump said.
I mean, not as shocked as I was to learn that he actually won California.
An excellent point. So, and speaking of which, I think actually the most surprising part of that burp is that Trump is almost right. I mean, it's by accident, of course, but there is a general policy at the Department of Justice not to interfere with an upcoming election. Okay. And so every year the DOJ reissues a memorandum that has been virtually unchanged since at least 2008. And that was when Republican and George W. Bush appointee, the then Attorney General Michael Mukasey, issued it through to today, right? We'll put the 2008 and the 2024 memoranda both in the show notes. The subject line is election year sensitivities, which is why the policy is internally referred to as that, as EYS, election year sensitivities, not the 60-day rule.
Yeah, no, I just want to break in here to say that this is one of the things that Bill Barr was willing to screw up for Trump, because Bill Barr absolutely abrogated the 60-day rule and announced kind of election interference investigations, made a big fuss about them in violation of that rule in a blatant attempt to bolster Trump's false claims about rampant vote fraud. So it's more than a little ironic that Trump is going oh, you can't prosecute me because 60-day rule.
Yeah, you're saying that Donald Trump's legal position is inconsistent.
Yeah.
I'm sorry. I've got my fainting couch here ready. Oh, okay. Look, the election year sensitivities memo has 2 parts. The second part is about the Hatch Act, which generally prevents government officials from engaging in certain kinds of political activities while they're on the job or using government resources. Now, that has nothing directly to do with the superseding indictment, but if you're a patron of the show at any level, you are going to get a frolicking detour about it right now. And if not, you're going to pick up with the first part of the memo that is directly about this right after this ad break.
So let's look now at Part 1 of the memo, which specifically applies that principle to the Department of Justice. It used to be titled Investigations and Prosecutions of Election Crimes and is now somewhat more expansively labeled as Statements, Investigations, and Charging Near an Election. And as you might suspect, the reason for adding statements in addition to investigations and prosecutions is, perhaps you recall, FBI Chief James Comey repeatedly flapping his yap every time Hillary Clinton opened up a significant lead over Donald Trump in 2016, even though about half of those were things Comey said after the FBI concluded its formal investigation.
Butter emails.
Oh, those butter emails. Okay, so pin in Comey for now. But as a result of his overt meddling in the 2016 election, the language now reads, the Department of Justice has a strong interest in the prosecution of election-related crimes, such as those involving federal and state campaign finance laws and corruption of the election process. Partisan politics must play no role in the decisions of federal investigators or prosecutors regarding any investigations or criminal charges. Law enforcement officers and prosecutors may never select the timing of public statements, attributed or not, investigative steps, criminal charges, or any other action in any matter or case for the purpose of affecting any election or for the purpose of giving an advantage or disadvantage to any candidate or political party. That's the policy. The Justice Department can't select the timing of its statements or actions for the purpose of affecting an election, which is, of course, what Trump has accused it of doing. And then the memo references the Justice Department manual, section 985-500, a section captioned actions that may have an impact on an election. And it says, federal prosecutors and agents may never select the timing of any action, including investigative steps, criminal charges, or statements for the purpose of affecting any election or for the purpose of giving an advantage or disadvantage to any candidate or political party, which is kind of the opposite of what Trump was trying to do the entire time to Joe Biden. Just do us a favor, though.
And you just read out all of the internal guidance, right, that the Justice Department has promulgated, put into writing. And none of that says 60 days, right? Not the law, not the regulations, not the Justice Manual, nothing. So if you're asking, how did this become a 60-day rule? The best answer I can come up with comes from a 568-page report by the Office of Inspector General for the Department of Justice that was issued in June of 2018, and it was titled A Review of Various Actions by the Federal Bureau of Investigation and the Department of Justice in Advance of the 2016 election. So pull that pin on James Comey. Yes, there's also some Pete Strzok, Lisa Page stuff in there. But basically, right, like a bunch of former DOJ officials weighed in to say, what the hell was James Comey doing, right? Like we were within 60 days of an election, and he was very clearly putting his thumb on the scale for Donald Trump. And here's how the OIG report characterized its fact-finding on what that informal policy meant. It says, the 60-day rule is not written or described in any department policy or regulation. Nevertheless, high-ranking department and FBI officials acknowledge the existence of a general practice that informs department decision. Former Director Comey characterized the practice during his OIG testimony as a very important norm, which is we avoid taking any action in the run-up to an election if we can avoid it. There is generalized, unwritten guidance that prosecutors do not indict political candidates or use overt investigative methods in the weeks before an election. People sometimes have a misimpression that there's a magic 60-day or 90-day rule. There isn't. But the closer you get to an election, the more fraught it is. That report then noted that multiple administrations have considered whether to codify the 60-day rule as an official policy, right, to say not within 60 days. But, quote, they rejected that approach as unworkable, end of quote. Prosecutors instead, quote, should be free to look to the needs of the case, and significant investigative steps should be taken when the case is ready, not earlier or later, end of quote.
Right. So TLDR, there's no such thing as the 60-day rule. I mean, there's the 60-day norm. And for Donald Trump to say, like, norms, I should have the norms. I should have the benefit of norms when he, we all were there. Okay. Second, even if there were, a superseding indictment was secured 69 days before the election. That's not 60 days. That is more than 60 days. And the trigger is not like you don't start the calendar like, oh, if there's some people who can like vote October 1 or September 15th, early voting starts early. That's when the 60 days starts. No, it's 60 days from November 5th. And third, even if it had violated the policy, the DOJ's manual is guidance. There are no substantive rights that come from violating internal policy guidance. And fourth, Most importantly, superseding indictment does not violate the principles set forth in the election year sensitivities memo because these are not new allegations, they're not new charges, they're a reduced set of the allegations initially brought a year ago on August 1. So Trump can't even plausibly argue that this is like Comey on October 28th, 2016, 11 days before the general election, just announcing that he had found newly discovered emails that appear to be pertinent to the, Hillary Clinton email investigation. Because this is not a new investigation into Trump. And regardless of whether Smith got a superseding indictment or not, the Supreme Court ordered Judge Chutkan to, go and do her work. And this is her work. And to evaluate the allegations in the indictment to see if they comported with the new rules the Supreme Court just made up in that immunity decision. So, no, the 60-day rule, not a thing in this case.
Yeah, and as you pointed out, this was going to be a topic of conversation as ordered by the U.S. Supreme Court, no matter what. This is not prejudicial. The timing was not designed to be prejudicial, right? Like, this is that the claim is just not there. So, all right, with that in mind, let's get on to our second story.
All right, so a bunch of you have asked us some version of what happens if Republicans try to subvert the election in 9 weeks. And yeah, fair. They are 100% going to do that if it looks like their guy lost. I wrote a piece for Aaron Rupar's Public Notice about changes to election regulations in Georgia specifically on this topic. We're going to talk here about what this effort looks like nationwide and particularly in Georgia. Because one of the main ways Republicans are preparing to sow chaos after the election and possibly to steal it is by making it easier for local officials to refuse to certify the vote.
Right. So in legal terms, they're trying to turn a ministerial exercise into a discretionary one, which is why you flagged that earlier. So look, some government jobs involve a set task, right? And you do not get to deploy judgment or decide whether or not to do it, right? That some jobs involve an exercise of discretion, right? Where you can decide how to go about it or whether to do it at all, right? And so the most famous, I think, example of this, where Republicans tried to convert a ministerial task into a discretionary one, was with Mike Pence, right? Where he had a ministerial job as assigned by the 12th Amendment to the Constitution and the Electoral Count Act. Open up the certificates and count them. And they wanted to say, no, that's actually discretionary. You can reject ones if you don't like them. You can choose to accept fake ones if you do like them. You could send it back to the states for further fact-finding, even though nothing says that, right? And to his, very minimal credit, right? Mike Pence said, no, I've talked to my lawyers. This is a ministerial responsibility. It would be against the Constitution for me to do what you're asking, and he didn't. And that was just the last step in a whole chain of efforts to try and convince people to give Trump electoral votes, despite the expressed Democratic preference of the voters.
Yeah, and I'm going to recount them, but just I think it's important to know that a lot of this is the Trump campaign trying to treat ministerial obligations as if they are discretionary. So first they lean on local officials, particularly state legislatures, whom they hoped would seize on this kind of amorphous yelling about fraud as justification to reconvene and claw back Biden's electoral votes, which mostly they didn't have the choice to reconvene. Like in Georgia, the governor has to, call them back into session. And that was one of the things that John Eastman said. John Eastman said, well, the Constitution says you can reconvene if you really wanna. And no, it doesn't. Right. Yeah. And then they went to the courts with some version of please throw out absentee ballots for reasons. So they filed a bunch of bullshit lawsuits. Rudy Giuliani explicitly asked a federal judge in Pennsylvania to adjust the vote tally in Pennsylvania, give Biden's votes a haircut based on these unproven claims of fraud. And when that didn't work, Trump went to the Justice Department and tried to get it to claim that there was fraud and functionally have Jeff Clark order the swing state legislatures to seize the electoral votes for Trump. And when that didn't work, they tried to have Pence invent this discretionary choice to certify the electoral votes when there was no discretion.
Yeah, and intriguingly, that they certainly now don't hold that position, right? They do not want Vice President Kamala Harris acting as president of the Senate to, have the choice in 2025 about which electoral votes to certify and which not to. I haven't heard John Eastman making that one lately.
Yeah, weird, huh? But this go around, they're trying to make it easier for election denying weirdos to screw around at the precinct and county level. And one of the ways that they've done this is to get those weirdos appointed to local election boards and then have them start behaving as if they have the authority to reject the vote tally if they don't like it. That was a strategy originally advocated by Bannon, who told his followers to go take over election boards.
Yeah.
Which they did. So they want to take purely ministerial positions where the local board counts the votes and reports the tally to the state, and then turn those into discretionary positions where these goons can refuse to certify or even screw with the tally. And that brings us to Georgia, where the state election board just adopted two new rules called the reasonable inquiry rule and the examination rule, both of which were in response to petitions filed by Republicans, and both were designed to give local officials more leeway to investigate and then refuse to certify the vote. So they essentially convert this ministerial obligation into a discretionary one. And I just want to flag, the law is not changing. What's changing are the administrative rules declared by the state election board, and those are definitely subordinate to the law.
Yeah, and procedurally, what happened here was that in March, Michael Heekin, a member of the Fulton County Board of Registration and Elections, and a known election denier who voted against certifying the March primary, petitioned to amend the state election board rules to impose an affirmative obligation on local election boards to, do your own research and investigate anything they find suspicious. And I just want to read a little bit of his petition because, as you like to say, Liz, he really puts the rabbit in the hat here, right? So the petition says, election officials are entrusted under Georgia law with the duty to conduct fair elections and properly tabulate, certify, and report the results. That's true. However, what it means to certify an election is not defined in either the Georgia Election Code or the state election board rules. This creates a challenge in the efficient administration of Georgia elections, especially when elections are not perfect, which they rarely are. For example, in the municipal elections last fall, the cast vote record reported that many voters had voted multiple times. This was believed possibly to have been caused by malfunctions in the voter information system. Also, recent municipal redistricting was not accurately reflected in the ballot styles given to many voters. There were clearly problems with the election in many places, but were they serious enough to consider not certifying the results? Election board members and others who referred to the Georgia Election Code and state election board rules for guidance on the standard for certification found that there was none. In the absence of a standard for certification, are superintendents performing a simple bureaucratic act of certifying the tabulated results of an election, even if those results are suspect, or are they entrusted to use their professional judgment in the certification process?
God, yeah, I have so many thoughts about this one. The first is, hey, you know why there's no standard for certification? Because it's not discretionary, right? If it was, the law would say, here is the rubric, certify if you, in your subjective opinion, think that the vote complied with it. It's not there because they don't intend you to use your subjective, opinion.
Right.
The second is this place called Antrim, Michigan, a place that neither one of us would ever have heard of if it wasn't home to this very unfortunate election clerk who failed to update her software and then had to go back the day after the 2020 election and revise the count because it was very clearly off. And human error, it happens, right? But then Trump and his goons put her at the center of a conspiracy theory where they tried to make this obvious, easily explained human error into proof that there was a system-wide vote flipping algorithm. And here, again, Heekin is doing exactly that. He's seizing on extremely normal stuff, like obvious errors that got sorted out and saying, that's weird and outrageous and nefarious, and we should have the power to investigate it so as to give confidence to, the people who I just lied to and said that there was something weird and outrageous and nefarious going on, right? Rabbit hat.
Yeah, exactly. So Heekin's proposed amendment imposes an affirmative obligation on the board members, quote, to attest after reasonable inquiry that the tabulation and canvassing of the election are complete and accurate and that the results are a true and accurate accounting of all votes cast in that election. So that's permission for them to go herring off after information and not certify the count until they're satisfied as to all the votes cast, right? And despite the fact that, they called this thing the reasonable inquiry rule, and Heekin was very adamant about terms not being defined, I note that the term reasonable inquiry is not defined.
Well, which is exactly what the plaintiffs said when they sued to block this rule, but we're going to come to that in a sec. The second petition was filed by Cobb County Republican Chairwoman Sally Grubbs because she wrote, "There is a crisis of confidence in our elections, and the oversight of elections in each county is critical to restoring trust."
And again, we're back to the goose meme that you hear, like, who created the crisis of confidence in elections, Sally? Who created the crisis?
Yeah, a lot of animals in this episode, and it's not even about RFK Jr.
Hey-o.
Yeah, she says, recently various parties have suggested that the board has no discretion to inspect the conduct of elections and no permission to review the returns for poll officers. In fact, some outside entities have asserted that the certification of election results in a county is nothing more than a ministerial task and that the members of the board have no discretion but to rubber stamp results sight unseen.
Yeah, they do say most of that, Sally. And you know why?
Yeah, I do. In fact, I do know. But okay, continuing. Although the language of the statutes is clear and unambiguous, the state election board should promulgate the proposed rule to ensure that members of the county boards can perform at a minimum their statutory duty unencumbered by outside influences and misunderstanding of the law. So Sally's proposed rule would authorize local election officials to go on an endless spelunk through all the polling documents and election equipment to satisfy themselves that the count is right. And that's bad, right? But the really alarming part to me is this clause here. After all precinct discrepancies have been investigated and resolved, as required by Georgia Election Code Section 21-2493, the correct or corrected returns shall be recorded until all the returns from each precinct which are entitled to be counted are recorded, and then they shall be added together, announced, and verified as accurate.
Yeah, all the alarm bells are going off here, right? Like that sounds like they've not only authorized a fishing expedition, but green-lighted board members to correct election returns. And that is clearly not what the law contemplates, right? Like, so first of all, Georgia Code 21-2-493, the one you referred to, is a non-discretionary statute. It uses the classic shall language that every lawyer and regular listeners of the show means that it's ministerial. Like, you can get mandamus to force a government actor to do that. You don't get to not certify. You don't get to correct results, right? Now, to be fair, the statute does lay out a very specific procedure for investigating discrepancies, and it's not that, right? So, for instance, Section 493B says, if, upon consideration by the superintendent of the returns and certificates before him or her from any precinct, it shall appear that the total vote returned for any candidate or candidates for the same office or nomination exceeds the number of electors in such precinct, or exceeds the total number of persons who voted in such precinct, or the total number of ballots cast therein, such excess shall be deemed a discrepancy and palpable error, and shall be investigated by the superintendent, and no votes shall be recorded from such precinct until an investigation shall be had. Such examination may, if the superintendent deems it necessary, include a recount or recanvass of the votes of that precinct and a report of the facts of the case to the district attorney where such action appears to be warranted. So, okay, I know that was a long section, but the superintendent means the local election board, right? And there are about a dozen provisions for what to do when there are specific discrepancies in the count, right? Not vibes, not I think I saw an Antifa voting after the time expired, right? Like, yeah. It's based on whether it's paper ballots or a machine with a paper tally, whatever, right? Matching up the votes against the total number of votes counted, right? But nowhere in there does it say that the board has the right to correct the tally based on anything, let alone their subjective interpretation. In fact, subsection I says, if any error or fraud is discovered, the superintendent shall compute and certify the votes justly, regardless of any fraudulent or erroneous returns presented to him or her, and shall report the facts to the appropriate district attorney for action, right? Which, okay, in fairness, that's not a model of clear drafting, right? But reading that as a lawyer, like I think any objective lawyer coming to this would say that if they suspect fraud, board members don't get to just correct it on their own and disenfranchise voters at will. What you do is you report the tally as it stands, right? Regardless of the fraudulent or erroneous returns, and then you give it to the the district attorney, right? You can ferret out Antrim County style tabulation errors, whatever, and you hand it over to the district attorney and say, here's the number, but I think the number is wrong for X reason, right? But it's up to the district attorney to then take that next corrective step.
Right. And they're, again, trying to convert this ministerial shall obligation into a discretionary one that would deputize board members to investigate imaginary fraud gremlins and justify endless harassing requests for more documents. And then, look, we don't have to guess what happens here because that is exactly what happened in both the municipal and presidential primaries in Georgia this year when Republican loons decided they'd start freelancing and ignore the statute. And it's happening like that across the country. That is the Republican plan. So according to the Atlanta Journal-Constitution, at least 19 election board members refused to certify elections in Georgia since 2020. And one of those was Julie Adams, an election denier who is also on the Fulton County Election Board. She refused to vote at all to certify the results of the May primary. She just kept demanding ever more granular data. And when election officials told her that the information was not readily available and she wasn't actually entitled to it, she withheld her vote, which is not a thing, right? That's not a thing when it comes to non-discretionary statutes. She has to certify the tally 6 days after the election, period. Also in May, Gwinnett County Board member David Hancock, he's yet another election denier, there are a lot of them, refused to certify based on purported chain of custody issues, which again, that's a vote integrity issue. It's not a math issue. And when it comes to certification, math is the only thing the board is supposed to be doing.
Yeah, and I just want to take a minute to emphasize that even if you are sincerely concerned about vote integrity, right, and you're not using it as a pretext for just throwing out results you don't like, which, I think we've demonstrated an abundance of that, there are established procedures for challenging the validity of the count, right? There's a system for mounting a challenge and getting a recount. And if you don't like that, you can file a lawsuit. That's the law. But there's no law that says individual board members can, play Vera Stanhope and go sleuth out the vote fraud. And in fact, the challenge can't take place. You can't file your lawsuit until the count is certified, which is why they have to certify the vote.
Yeah. And hello, in the least twisty twist ever, it turns out that Heekin, Adams, and Hancock, the ones who refused to certify, they were in touch with the MAGA members of the state election board and dummied up this rule change to give themselves cover to ask for ever more records in preparation to fuck up the 2024 election. Reporter Justin Glowey foiled their communications and found out that they and several other MAGA board members across the state were in contact. We'll link to that story in the show notes. It's in Rolling Stone. It's really interesting. But okay, now we're going to talk about the lawsuit at long last. It was filed by the DNC, the Democratic Party in Georgia, and several Democratic electoral board members who, they're usually, like, for instance, the Fulton County board is 5 members. It's 3 of them, Heekin, Adams, 1 other, and 2 Democrats. So, okay. They're the plaintiffs in this case. It was filed in the Superior Court of Fulton County, where it was assigned to Judge Robert McBurney. And if that name sounds familiar, it's because he presided over the special purpose grand jury that considered the case against Donald Trump and 18 of his goons in Fulton County. And that was the precursor to the RICO indictment. So Judge McBurney is a very competent judge. I feel very good about him here.
Yeah, me too. The DNC plaintiffs make a lot of the claims that we just talked about in their lawsuit, right? So, for example, they said, the primary and narrow purpose of county certification is to ensure that the aggregate tabulation is numerically accurate. Other steps in the election process, which occur both before and after county certification, address the possibility of fraud. These steps include voter registration, voter verification at the polls, the risk-limiting audit process, and the election contest process. And then the lawsuit cites the plain language of the statute as proof that certification is non-discretionary, along with multiple Georgia Supreme Court cases that are directly on point. I got to give you at least 2 here, right? So, for example, the Georgia Supreme Court held in Tanner versus Dean, that's from 1899, that certain county superintendents' refusal to certify an election was subject to mandamus, right? That is, because it's a shall, they have no discretion. And it ordered the lower court to issue a writ of mandamus requiring the superintendents to certify the results. Similarly, Bacon v. Black, that's from 1926, held that certification was a purely ministerial duty that left no discretion for any superintendents to investigate issues of irregularity or fraud. So, for more than a century, this has been settled law in Georgia. These positions are legally frivolous. And then the DNC plaintiffs go on to talk about the danger of total disenfranchisement of a county's voters if the board just refuses to certify. And if you think about the fact that Gwinnett and Fulton County make up the Atlanta metropolitan area, which is where Democrats live, that would absolutely, it wouldn't matter what the results were in the rest of the state. That would absolutely flip the state of Georgia to Donald Trump.
Yeah, I particularly appreciated the lawyers calling out the state election board for trying to kind of sit in the cut here. And the election board's position is basically, there's a legal interpretation of this rule. If you squint at it just right, it's legal. And even though everyone involved says that they mean it the illegal way, we, the board, would like you to take us at our word that we're just affirming an existing statute and let this law stand. No, if that were the case, then they wouldn't be bothering to change the rules. The reason that they're changing the rules is the reason that they've said that they're changing the rules, which is that they, want not to certify if they don't feel like it. So here's what the plaintiff said. In theory, both rules could be read as facially consonant with Georgia statutes by permitting only such reasonable inquiry or examinations as would not delay certification beyond the statutory deadline, much less prevent certification from happening at all. But that is not what the drafters of those rules intended. To the extent either rule does allow election officials to delay certification or not certify, as the rule's drafters avowedly intend, it is invalid. So, the petitioners are asking for a declaratory judgment from Judge McBurney that certification of the election is non-discretionary, and they want the court to enjoin any unlawful application of the rules to permit board members to investigate or withhold certification while they go fishing around for, documents or the proof of the Chinese Bluetooth spy, whatever. But more broadly speaking, this is not just a thing that's happening in Georgia. Trump and Ronna Romney McDaniel leaned on officials in Wayne County in 2020 not to certify Detroit's votes, which would have flipped the state. There were several county election officials who had to be sued in 2022 to do their jobs, and they had to be mandamused in order to do it. I think that was particularly in Arizona and Nevada. And local officials are gearing up to do this across the country. They're just not going to do their jobs. They're going to say we don't know if it's valid, or they're going to say it's not valid. And the point is we have to kind of push back on this because, look, there's a reason that they're doing this. This is loosening the screws at multiple points of the electoral process and hoping that, if they need the system to fail, they can push on it where it's already been, there's the joints are unstable and the whole edifice will collapse, right? This is pre-breaking it just in case they need to do what they, failed to do in 2020.
Yeah, it's using 2020 as a trial run, right? Because after the election, the Trump administration was kind of making it up on the fly, right? The emails from John Eastman and Ken Chesbrough show that, right? They were concocting these theories. And by that time, they had to actually flip electoral votes. But, and I just want to make sure that this is pellucidly clear for everyone, what you can do instead is if you just throw enough of a monkey wrench into the system, if you just delay the reporting of results from places like Wayne County in Michigan, from places like Fulton County in Georgia, and you have to report a zero, you have to go forward with nothing, with missing deadlines, then that will wind up in statewide vote totals that are skewed Republicans. And if that happens, right, that is outright stealing the votes of the state without having to convince anybody to affirmatively flip or change votes. You just don't do your job in areas that just happen to come in 80+% Democratic.
Yeah, I mean, I think if there's anything to kind of take hope from here, it's that everybody sees them coming. Everybody's ready. The courts are ready. We are ready. There are a lot of Democratic lawyers are ready for this. And, there is law on the books. It makes it pretty clear. And also, we have the safe harbor deadline of December 14th. If some state screws it up, if Republicans in Georgia manage to screw it up, and I don't think that Secretary of State Brad Raffensperger is going to put up with a lot of shit. He didn't last time.
Yeah.
I mean, I think And now we have, we have the Secretary of State in Arizona is a Democrat, and we have a lot of statewide offices in many of the swing states, like in Arizona and Nevada, and in Georgia, it's Brad Raffensperger. So, fingers crossed.
Fingers crossed.
All right. Well, that's going to do it for us today. Thank you guys so much. And we will not have written content on Monday because it is Labor Day, but we will be back on Tuesday as per usual.
See you then.
Thanks, guys.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Ipsa Media, LLC, all rights reserved.